Good day everyone, especially to you ma'am. I'm Criscia Autentico and today I'm going to discuss to you the chapter 12 of Philippine tourism laws, which is the laws related to tourism and investment and finance. But before that, let me read to you this first. Teach men how to start a business, and you feed him a lifetime. It is according to Jose Maria Concepcion the third, founder of Go Negosyo Summit. And now let me introduce to you to our topic outline. First is Foreign Investment Act of 1991. Second is the investment in transportation business and public utility. Third is investment in travel agencies and tour operators. Next is the investment in hotels, resort, and other accommodation establishments. Application of the retail trade law of restaurants and shops. Next is the tourism project under the Build, Operation, Operate, and Transfer or BOT program. Next is the applicable negotiable instruments and documents of the title. Next is the financing. Next is the credit card. Next is the Special Economic Zone Act of 1995, Republic Act 7916. Is the business models. And next is the franchising. Next is the taxes. And for the last topic is the Barangay Micro Business Enterprise Law. And by the end of just this chapter, our learning objectives is enumerate the procedure in setting up a tourism-oriented business. Next is explain the laws governing tourism investments and financing, tourism-oriented projects, and tech. Next is the discuss the business models applicable to tourism projects, and lastly is to enumerate the various taxes application to tourism-related establishments, and lastly is the discuss the limitation of foreigners in tourism investments. It has been the policy of the state to recognize the indispensable role of the private sector like the tourism industry and the private incentives for its needed to investment. This chapter deals with the laws related to promotion, monitoring, and regulation of tourism investments and finance in the country. Basically, this will tackle the participation of foreign investors as well as the incentives given to Filipinos in case they will invest in the tourism industry. Especially laws are even created to address needs of certain sector like the informal sector, Filipino balikbayans, retirees, and senior citizens. And now let's proceed to our first topic, which is the Foreign Investments Act of 1991. The term Philippine national shall mean a citizen of Philippines or a domestic partnership or association wholly owned by citizens of the Philippines, or a corporation organized under the laws of Philippines of which at least 60% of the capital stock outstanding and entitled to vote is owned held by citizens of the Philippines, or a corporation organized abroad and registered as doing business in the Philippines under the corporation code of which 100% of the capital stock outstanding and entitled to vote is wholly owned by Filipinos, or a trustees of funds to pension or other employee retirement or separation benefits, where the trustee is Philippine national and at least 60% of the fund will accrue to the benefit of the Philippine nationals, provided that where a corporation and its non-Filipino stockholders own stock in the Securities and Exchange Commission or SEC registered enterprise, at least 60% of the capital stock outstanding and entitled to vote of each of both corporations must be owned and held by citizens of the Philippines, in order that the corporation shall be considered as a Philippine national. In the Republic Act 7042, as amended by Republic Act of 8179 on March 25, 1996, also known as the Foreign Investments Act of 1991, provides for the policy that foreigners can now invest in all activities and enterprises in the Philippines except those covered in the negative lists. When a foreign investment in the Philippines is not covered or does not seek incentives under the Omnibus Investment Code, the foreign national or entity can ascertain the extent of the allowable foreign equity in the enterprise so to be entered into by simply referring to the negative lists and filing the necessary requirements with the Security and Exchange Commission. Under the Foreign Investment Act of 1991, FIA 1991, a foreign national or entity or equity must determine the kind of enterprise so to be entered into, whether the enterprise is a domestic market enterprise or an export enterprise. And now let's proceed to our next topic, which is the investment in transportation business and public utilities. Article 12, National Economy and Patrimony. Section 11, no franchises, certificate, or any other form of authorization for the operation of public utility shall be granted except to citizens of Philippines or to corporations or associations organized under the laws of the Philippines, or at least 60% of whose capital is owned by such citizens, nor shall such franchise certificate or authorization be exclusive in character for a longer period than 50 years. Neither shall any such franchise or right to be granted except under the condition that it shall be subject to amendment, alternation, or repeal by the Congress when the common good so requires. The state shall encourage equity participation in public utilities by the general public. The participation of foreign investors in the governing body of any public utility enterprise shall be limited to their proportionate share in its capital, and all the executive and managing officers of such corporation or association must be citizens of the Philippines. For common carriers such as the airline, land, and water transportation business, the operation of such involved public service which shall be granted only to citizens of the Philippines, or to corporations or associations organized under the laws of the Philippines, or at least 60% of whose capital is owned by such citizens. In other words, foreign participation is limited to only 40%. In addition, the executive and managing officers of the corporation or association operating a transportation business shall be exclusive to citizens of the Philippines. And now let's proceed to our next topic, which is the investment in travel agencies and tour operators. The following may apply for the accreditation as tour operator. A is a resident Filipino citizen. B is a partnership organized under the laws of the Philippines, at least 60% of its capital being owned by Filipino citizens. And lastly, corporations organized under the laws of Philippines, at least 60% of the subscribed common or voting share or stocks of which is owned by the Filipino citizens, and the composition of its board of directors being at least 60% Filipinos. The limitations of the foreign participation to 40% for purpose of accreditation and operation of a travel agency and or travel operator by the Department of Tourism. In addition, Memorandum under number 211 approving the 2006 investment prioritized plans on April 4, 2006, tourism, which covers travel agencies or tour operators, has been classified as preferred activities pursuant to Article 29 of the Omnibus Investment Code of 1987. Thus, in order for a travel agency or tour operator to be entitled for registration under the investment proprietors plan. And now let's proceed to our next topic, which is the investment in hotels, resorts, and other accommodation establishments. by reason of the enactment of Memorandum Order number 211 approving the 2006 Investment Priorities Plan. On April 4, 2006, tourism has been classified as referred activities pursuant to Article 29 of the Omnibus Investment Code of 1987. Tourism covers the development of tourism economic zones, tourist states, eco-agritourism facilities, and establishments of tourism accommodation facilities like hotels, resort, and other tourism accommodation facilities such as apartel, pension houses, tourist inn, and similar establishments. Thus, in order for the tourist accommodation facilities to be entitled for registration under the investment priorities plan, an applicant must satisfy the Board of Investments that A. He is a citizen of the Philippines in case the applicant is a natural person or in case of partnership or any other association. It is organized under Philippine laws and that at least 60% of its capital is owned and controlled by citizens of the Philippines, or in case of a corporation or a cooperative, it is organized under Philippine laws and that at least 60% of the capital stock outstanding entitled it is the vote owned by and held by the Philippine nationals as defined under Article 15 of Omnibus Investment Code, and at least 60% of the members of the board of directors are citizens of the Philippines. B. As the applicant is proposing to engage is an preferred project listed of the authorized in the current investment priorities plan within a reasonable time to be fixed by the board. And lastly, the applicant is capable of operating on a sound and efficient basis of contributing to national development of the preferred area in particular and the national economy in general. Now let's proceed to our next topic, which is the application of the retail trade law of restaurants and shops. Restaurants and other tourism-related establishments, such as department stores and shops, are governed by the laws on retail trade by reason of the nature of their business. In the past, operation and ownership of these establishments are confined only to Filipino citizens or to corporations and associations fully owned by Filipino citizens. By reason of the enactment of Retail Trade Liberalization Act of 2000, foreign investors may now engage in retail trade subject to capital requirements. Refer to Chapter 10, Laws Regulating Restaurants and Other Tourism-Related Establishments. The following sales transactions are exempted under the coverage of the Retail Trade Liberalization Act of 2000 and are therefore allowed 100% foreign ownership participation. A is by a manufacturer, process, labor, or workers for the general public, the products manufactured, processed, or product by him if his capital does not exceed to 100,000 pesos. B is by a manufacturer of his products in single outlet irrespective capitalization. C is restaurants incidental to the hotel business. And now let's proceed to our next topic, which is the tourism projects under the Build, Operate, and Transferred BOT program. The Republic Act, as amended by Republic Act of 7718, referred to the BOT law, implements the declared policy to the state to recognize the indispensable role of the private sector of main engine for national growth and development and provide the most appropriate favorable incentives of mobilize the private resources for the purpose. The coverage of the BOT law extended not merely to government infrastructure projects but also to government development projects. The following are the scheme recognized under the law. The build and transfer, a contractual arrangement whereby the project permanent undertakes the financing and construction of the given infrastructure or development facilities, and after its completion, turn it over to the agency or LGU concerned. Next is the build, lease, and transfer, or the BLT, a contractual arrangement whereby a project permanent is authorized to finance and construct an infrastructure or develop facility, and upon its completion, turn it to the agency or the LGU concerned. And next is the build, own, and operate, the BOO, a contractual arrangement whereby a project permanent is authorized to finance, construct, own, operate, and maintain an infrastructure or development facility from which the project permanent is allowed to recover its total investment. Next is the build, operate, and transfer, or the BOT. It is a contractual arrangement whereby the project permanent undertakes the constructions, including finance of given infrastructure facility, and the operation and the maintenance duty. This is the build, transfer, and operate, or BTO, a contractual arrangement whereby the agency or LGU construct the construction for an infrastructure facility to private entities, such as the contractor build the facility on a turnkey basis, assuming cost overruns, delays, and specified performance risks. Next is the contract, add, and operate, or the COA. The contractual arrangement whereby the project permanent adds to an existing infrastructure facility which is renting from the government and operates the expanded project or over the agreed franchise period. Next is the develop, operate, and transfer, or the DOT, a contractual arrangement whereby the favorable conditions extreme or external to a new infrastructure project which is to be built by project permanent are integrated in the arrangement. Next is the rehabilitate, operate, and transfer, or the ROT, a contractual arrangement whereby an existing facility is turned over the project permanent to refurbish, operate, and maintain for the franchise period. And lastly, the rehabilitate, own, and operate, the ROO, a contractual arrangement whereby an existing facility is turned over the project permanent to refurbish and operate with no time limitation imposed on ownership. Any individual, partnership, corporation, or firm, whether local or foreign, including joint venture or consortia of local, foreign, or local and foreign firms, subject to limits herein set, may participate or apply for pre-qualification projects covered under the law or the provisions of the Act. And now let's proceed to our next topic, which is the applicable negotiable instruments and documents of the title. By way of introduction, the laws applicable for purpose of discussion of the different negotiable instruments and documents of title in tourism investments are followed. Act of 2031, also known as the negotiable instruments. Second is the Presidential Decree number 115, providing for the regulation of trust receipts transactions, and third is the Warehouse Receipt Law Act of 2137. The following are some negotiable instruments and documents of which can be useful in tourism financing and investment. And now let's proceed to our next topic, which is the financing. And the General Banking Law of 2000, Republic Act of 8791 was enacted based on the following. State policy. The state recognizes the vital role of barracks in the providing an environment conducive to the sustained development of the national economy and the fiduciary nature of the banks that require higher standard of integrity and performance. In furtherance thereof, the state shall promote the maintain a stable and efficient banking and financial system that is globally competitive, dynamic, and responsive to the demands of the developing economy. The term bank generally is a corporation form of the purposes of maintaining savings account, checking accounts, and issuance loans and credit, and dealing with the negotiable securities issued by governmental entities and corporations. Banks earned money by investing their customers' deposits. In order to protect the customers against loss, banks are strictly regulated by the Bangko Sentral ng Pilipinas. Loans stipulated between entities and banks are regulated by the General Banking Law of 2000. However, the parties are free to stipulate additional clauses, terms, and provisions as they may seem convenient. These stipulations are not contrary to General Banking Law of 2000, morals, good customs, public order, and public. And now let's proceed to our next topic, which is the credit card. Section 3. Access device means any card, plates, code, account number, personal identification number, or other telecommunication service equipment or instrumental identifier or other means of account access that can be used to obtain money, goods, services, or any other things of value, or to initiate a transfer of funds other than a transfer originated solely by paper instruments. Section 3F. A credit card is any card, plate, coupon book, or a credit device existing for the purpose of obtaining goods, property, labor, or services, or anything of value on credit. Section 3I. Open-end credit plan means consumer credit extended on the account pursuant to a plan. A credit card is defined as a small card establishing the rights of holder to credit on certain purchase such as meals, lodging, gasoline, or merchandise. It is wallet-sized identification card that enables its holder to buy products and obtain services on credit from one or a variety of business firms. The Access Device Regulation of Act RA 8484 seeks to protect the right and define the liabilities of parties who deal in credit cards and other access devices. Under said law, any application to open a credit card account under an open-end credit plan or solicitation of open such as account either by mail, telephone, or other means shall disclose in writing or orally the following information: A. Annual percentage rate. B. Is annual and other fees. Section 4 RA 8484. In this regard, the credit card issuer must provide, to the extent practicable, a detailed explanation and a clear illustration of the manner by which all charges or fees are computed. Section 5 RA 8484. However, disclosure required above may be omitted in any telephone solicitation or application if credit card issuer does not impose any annual periodic or membership fee. B. Does not impose any fee in connection with telephone solicitation unless consumer signifies exception or acceptance using the credit card. And C is disclose clearly required information in writing within 30 days after consumer requests the card, but in no event later than the date of the card delivery. And lastly is disclose clearly that consumer is not obligated to accept the card or account, and it is not obligated to pay any fees or charges to close unless consumer accepts the card account by using the card, or Section 6 RE 8484. And now let's proceed to our next topic, which is the Special Economic Zone Act of 1995, Republic Act of 7916. The law provides for a legal framework and mechanism for the creation, operation, and administration and corporation of special economic zones in the Philippines, creating for this purpose the Philippine Economic Authorities and for purposes. On October 7, 2002, the Department of Tourism entered into Memorandum of Agreement or MOA with PEZA that we would grant special economic zone status to tourism development zones and tourism states upon registration with PEZA, subject to the issuance of the required presidential proclamation. The PEZA shall consider for registration tourism or tourist-oriented enterprises to be located in PEZA registered tourism development zones, tourism states which are enclosed by the DOT as enterprise that will be established and operated with foreign tourists as primary clientele. The incentive available are A. Up to 100% foreign ownership of local or locator enterprises. B. Income tax holiday ITH for 6 years for the pioneer firms and 4 years for the non-pioneer firms. If a non-pioneer firm is located in the less developed area, it shall generally be entitled to 6 years ITH. C. After the ITH period, the option to pay a special 5% tax on gross income in lieu of all the national and local taxes except real property taxes. Tax and duty pre-importation of capital equipment required for the technical viability of the registered tourism activities. E. Special investors resident visa. F is employment of foreign nationals and other incentives as may be determined by the PEZA board. And now let's proceed to our next topic, which is the business models. Joint venture. In a joint venture, which is similar to partnership, two or more persons bend themselves to contribute money, property, or industry with the intention of dividing the profits among themselves. People versus Caballero 24059 CR August 26, 1981. To constitute a joint venture, there must be an agreement to enter into undertaking in objects or which parties have community or interest and common purpose of performance, and each of the parties must have an equal voice in the manner of its performance, control over agencies used therein, though one may entrust performance to others. A joint venture is distinguished from the partnerships in such a way that joint venture may or may not attain a juridical personality. If qualified as partnership under the Civil Code, it is taxable as a corporation, and if not qualified as a partner, if it has no juridical personality. Corporation may enter into a consortium among themselves to finance specific venture and divide the profits according to the term of agreement. Joint ventures, while not expressly recognized as such under the Civil Code of the Philippines, are afforded that same legal status as a partnership. Consequently, because the tax rules for partnership are harsher than for corporation, joint venture established in the traditional sense tend to be uncommon. The more common approach is to establish a new corporation with the joint ventures holding shares in the corporation. And now let's proceed to our next topic, which is the franchising. A franchise is a privilege given to a dealer by the franchise service organization to sell franchisors' product or services, including trademarks and trade names, in a given area, with or without exclusivity. Such arrangements are sometimes formalized in the franchising agreement, which is a contract between a franchisor and the franchisee, wherein the former may offer consultation, promotional assistance, and financing and other benefits. The franchisee must pay a franchise fee for such right. In addition, the franchisee is typically required to use the franchisor's product. A franchise is a license from the owner of the trademark or trade name, permitting others to sell product or service under the name or mark. More broadly stated, a franchise has evolved into the elaborate agreement under which the franchise undertakes a conduct a business or sell product or services in the accordance with the methods and procedures prescribed by the franchisor, and the franchisor undertakes to assist the franchisee through advertising, promotion, and other advisory services. A franchise agreement involves multiple licensing of intellectual property like trademark, trade names, and service marks, among others. Such licensing is governed by the rules or technology transfer agreements. The term technology transfer agreements refers to contract or agreements involving the transfer of systematic knowledge for the manufacture of the product, the application of the process, in the rendering of service, including management, contract, and the transfer, assignment, or licensing of all forms of intellectual property rights, including licensing of the computer software, equip computer development for the mass market. Under Public Act of Number 8293, also known as the Intellectual Property Code of the Philippines, the term intellectual property rights consists of copyright and related rights. B is trademarks and service marks. C is geographical indication. D is industrial designs. E is patents. F is layout designs, topographies of integrated circuits, and G is protection of the undisclosed information. And now let's proceed to our next topic, which is the taxes. Taxes on income, generally active business into income business earned by individuals is subject to graduated rates between 5 to 32%. Personal exemption is granted to single individual or married individual judicially decreed by as legally separated with no qualified defendants, with 2,000 head family 25,000 and married individual is 32,000. There is allowed an additional exemption of 8,000 pesos for each dependent, not exceeding 4. The active business of corporation, on the other hand, is subject to a flat of 35% rate. The tax rate will be reduced to 30% in 2009. Passive income such as interest, royalties, and dividends are subject to final withholding taxes, which are withheld at source. The applicable rates or final withholding tax vary depending on the type of income involved and the taxpayer. Corporations, including partnerships, are classified as domestic or foreign depending on the place of corporation or organization. A domestic corporation is a corporation organized under the Philippine laws. A foreign corporation is a corporation organized under the laws of the foreign country, and the foreign corporation is either resident or non-resident. And now let's proceed to our last topic, which is the Barangay Micro Business Enterprise Law. The Barangay Micro Business Enterprise Law Act of 2002, RA 9178, July 2022, 2002, was enacted to hasten the country's economic development by encouraging the formation and growth of barangay microbusiness enterprises, which effectively serve as seedbeds of Filipino entrepreneurial talents and integrating those in the formal sector with the mainstream economy. Barangay microbusiness enterprises, hereinafter referred to as BMB, refers to any business entity or enterprise engaged in the production process or processing or manufacturing of product or commodities, including processing, trading, and services, whose total assets, including those arising from loans but inclusive of the land on which the particular business, including those are like entities, office, plant, and equipment are situated shall not be more than 3 million pesos. Any person, a natural, juridical, or cooperative or association having the qualifications of barangay microbusiness enterprise as defined may apply registration as BMBE. For the procedure for registration is the following. An applicant of BMBE shall go to the office of the municipalities or city treasurer where the business is located. B is the applicant shall accomplish BMBE Form 1 in a triplicate and submit to the office of the municipal or city treasurer. C is the municipal or city treasurer evaluates the application. Application shall be processed within 15 working days upon submission of complete documents. Otherwise, the BMBE shall be deemed registered. And lastly, a registered BMBE shall be issued ECA as proof of registration, which will be effective for a period of 2 years, renewable for a period of 2 years for every renewal. All BMB shall be exempted from income tax for income arising from the operation of the enterprise. The local government units are encouraged either to reduce the amount of local taxes, fees, and charges imposed or to exempt the BMBA from local taxes, fees, and charges. The BMBAs shall be exempted from the coverage of minimum wage law provided that all employees covered under the Act shall be entitled to same benefits given to any irregular employee, such as social security and healthcare benefits. And that's all from our report. I hope you learned something and thank you for listening. Have a good day.